Hello everyone, I'm Mariam Asad and today we will be talking about legal criteria of statehood. This presentation will be a brief introduction of what can it mean to have a statehood and what can it mean to be a state. Prior to that, we will be moving forward to looking at what are the subjects of international law because they are important in knowing the idea of statehood. All right, so let's look at what it means to be subject of international law. Being a subject of international law means that international law is applicable on it. Subjects are obliged by international treaties. They have to abide by certain duties and possess certain rights. So just like a human being, you have certain rights and you have certain duties as well. In international law as well, in order to be a subject of international law, meaning in order for international law to protect you, you need to have certain rights and certain duties. And if any entity has that certain rights and duties, then they can be subject of international law. States are one of the primary subjects of international law. Some other subjects that are part of international law are international organizations, individuals, other territorial entities, and so on. So in short, if I have to conclude this part of the slide, then subjects of international law are those which have legal personalities, which means they have certain rights and duties, just like we human beings have personalities and we are recognized by our states. In order for a subject to be international law, they have to be recognized by international law by possessing the legal personality. Now, coming towards the legal criteria of statehood, this criteria was confined in Montevideo Convention 1993, according to which a state, in order to be a state, needs to have four certain criteria. First one being permanent population, second, a defined territory, third, a government, and fourth, capacity to enter into international relationship. Now, moving forward, we will be looking at each criteria individually with examples, and we will be elaborating on that. First of all, let's start with permanent population. What it means to have a permanent population. It means to have a nationality of the state. For instance, if I am a citizen of Pakistan, that means I have nationality of Pakistan. And I have to be permanently residing in that state. So these are the two criteria that define permanent population. Now, the thing here to notice is that the permanent population does not, the size of the population in permanent population does not matter. For instance, China and India are the biggest populated countries in the world. Similarly, we have Vatican City as well, which is one of the least populated country and also a recognized state. So it shows us that the size of the population in defining the criteria of statehood does not matter. All you need is a permanent population, which means having citizens and permanent residents. The next one we have is defined territory. Having a defined territory means that you have a stable political community. Now, in territory, this criteria of statehood is not strictly defined, which means that international law has been very lenient in looking at territories of the state in defining their statehood. The examples we have here is of Israel and Bosnia. We know that Israel is still in conflict with Palestine regarding their territories. So having a defined territory is not a set in stone requirement of statehood. The idea of independence here is more important, which means that there is a formal constitutional independence, and that is enough for determining statehood. Next, we have effective government. Having an effective government means it's a third criteria, and it means having a functional government. What it means to have a functional government is that you have a legislative and a functioning government body, which means you have laws and regulations and constitution and all that. What needs to be established for a stable political community is that there is a centralized authority in that state and there are legislative organs that are functioning. The states have liberty to choose the type of government they want to implement in their state. So there is no restriction on that with regards to what type of government a particular state want to choose. International law give states freedom in that sense that they can choose whatever form of government they want to operate in their particular states. However, there are certain exceptions in having effective government. By exception, I mean that if there is no government operating in that particular state, it does not mean that the criteria of statehood will not apply and that particular state or a country will be excluded and will not be recognized as a state. Exception for that we have is Iraq's invasion and occupation of Kuwait in 1990. That happened when Iraq invaded Kuwait and occupied it. So during that time, Kuwait did not have any effective government or you can say centralized authority or legislative organs. But that does not mean that Kuwait suddenly stopped being a state. So that's an exception. The other exception that we have is UN recognizing the state of Congo 1960 and Anglo 1975 when they were involved in civil war. So when there was a civil war going on, international law did not suddenly stop recognizing them as a state. So there can be exceptions that can be made in effective government, part of the statehood. And next we have is forming international relationship. This is one of the most definite and most important criteria of establishing statehood. It is considered a decisive criteria of statehood. It shows the independence of a state to form relations without interfering from any other state. What it means to have international relation and ability to form those relations is that the states are independent in their decisions. They are not influenced by any other state. Let's say there is a state A and there is a state B, and state B is influencing state A's relationship with other countries, and restricting it to certain limits. Then we cannot say that state A is a free state or fulfills the criteria of statehood. A state has to show that it is independent in making its own decision, and hence forming international relations come within that criteria. Now, capacity to enter into international relationship means that having capacity to sign treaties, ability to form diplomatic relations with another state, certain rights and duties in international community. So if a state fulfill all these criteria, that they are able to freely sign treaties, international law, they are able to form diplomatic relationship with other states, and they do possess certain rights and duties in international community, meaning they have legal personalities in international community, then they fulfill the criteria of statehood. This particular criteria of international law, this particular criteria of statehood is also linked with the concept of recognition, which means that how many states recognize that particular state as a state or a country. For example, we saw the example of Israel, in which we saw that there is no set defined territory of that particular state. However, it is still recognized by other countries as a state. So therefore, it has the ability to form international relationship, and hence it fulfills the criteria of statehood, and hence is recognized as a state in international community. So that's all from our side.